Well, there's a lot to know under the ADA. I would say if I could distill it down to three key things, the first thing would just simply be to get to know the accommodation process as a process, because that's what it is. An employer has to provide reasonable accommodations based on individualized assessments, not only with respect to what's being asked of the employee, from the employee, but also what the employer might respond with, whether it's a hardship. And it's a two-way street. It requires input from both the employer and the employee. Next, I would say would be understand that it's confidential. So when a request is made, first and foremost, it's something that should be kept sensitive. It should only be disclosed to HR representatives and need-to-know management. Naturally, much of the time, there's medical information involved. So that is also something that has to be kept very sensitive. It even needs to be separated out from other sensitive employee information. And I would say third, be mindful that it applies to all phases of employment. I frequently see issues, for instance, where employers aren't fully aware of the need to potentially accommodate even in the interview process because they think, well, this person isn't an employee yet. But if a request comes in, it's something that needs to be honored in terms of how they're going to conduct the interview. And employers need to be mindful of the types of questions they ask in interviews so that they're not particularly or potentially asking disability-related questions. And so, good guidance is really needed across all phases of the process, and it needs to be understood as that, as it's a comprehensive process that a company needs to be aware of.